there are three important or key aspects to the modernization rule that I wanted to touch upon. The first one is they talk about bringing back the contracts and work orders, in a consulting company scenario where, the H1s are being filed by IT consulting companies where the beneficiaries are working for third parties. Previously, they would ask for contracts and work orders between all the possible parties, between the vendor, the end client, the sub-vendor, and they would ask for these contracts to be valid for the validity of the H1. So if we're asking 3 years on a H1, they would ask for a validity of the PO for 3 years. Otherwise, they would give the H1 for a lesser time. So then in 2020, there was a lawsuit filed by ITServe versus Cissna. And in this lawsuit, it was decided that it's unlawful to ask for the itineraries and detailed contracts. So USCIS agreed then not to ask for detailed itineraries and not to ask for contracts for the entire duration of the H1. As a result of which now H1s are being approved. They can still ask for work orders and contracts to a certain extent. They want to know if there is availability of specialty occupation work or not. And, based on that, they can ask for it, but they haven't been doing that as much. But now with the modernization rule, they're trying to bring back that as a regulation so that the court order will then be null and void because there's an actual regulation to that effect requiring, proof of specialty occupation work. And so they're trying to bring back those, the requirement to provide contracts and work orders for the entire duration of the time. They have, however, have said that detailed itineraries would not be required as, that information is on the LCA anyway. So you don't have to show that you have work for the entire period of time, but you have to show that you have some specialty occupation work. And then they might ask for contracts and work orders and MSAs and POs between all the parties involved if there's more than 2 parties involved.